Right, this is LAWS 12066 Land Law, and this is the lecture for topic 10 on mortgages. It's the last topic, folks. It's the last topic in the unit. My goodness, we've finally arrived. And where should we light in this last topic but on this area of security interests in land, mortgages. And we've seen in the Term 1 course that we looked at security interest in personal property under the PPSA. We're now lastly looking at nature of how property law governs and regulates these important security interests in land, which in truth is the mechanism that facilitates much of the transactions in regard to land, as purchases need to be financed on the nature of the value of land in terms of purchase and acquisition costs means that finance needs to be arranged and funds need to be borrowed most typically. And organisations today, mostly banks, that are lending funds to facilitate those property transactions require some security if something goes wrong in terms of the borrower being able to repay their debt. And yes, there is a loan contract that's entered into, but of course that's not going to be adequate if there isn't any funds. You can't sue the person if they don't have any funds. So what the lender wants is a security interest in the property, and that's what the mortgage gives, and that's the mechanism that's used, and it's a property law relationship that's created. So let's have a look at the slides to see where we're going. So we're doing the topic on mortgages, and we are concerned to have a look at the nature of what a mortgage is, the particular focus on the Torrens system, because in Queensland we have all private freehold essentially is Torrens title. So we're concerned to understand the nature of a Torrens title mortgage, to appreciate that we have the National Credit Code in place that is about providing protections particularly for domestic borrowers in relation to residential purchase transactions, and that is relevant with regard to the loan contract and the nature of the rights and responsibilities between the parties there. And then, of course, we've got both parties to the mortgage relationship, mortgagor and the mortgagee. Now, the mortgagee is essentially the entity taking the security interest in the land. That is most typically today the bank. The mortgagor is the landowner under the Torrens system, the registered proprietor, who is acquiring the indefeasible title in the land as RP under the Land Title Act, but is requiring finance to facilitate the transaction and is giving security interest to the lender in the nature of a mortgage, and they get a security interest under the Land Title Act in the land. It's important to appreciate that. So we're looking at the role of the mortgagor, the mortgagee, and then importantly looking at the nature of the mortgagee's powers on sale, so that the legislation creates a power in the mortgagee to be able to sell the property in which it has the security interest if the borrower is in default under the mortgage. And then lastly, this idea of mortgagees' remedies of foreclosure. Now, what's interesting, of course, is that in the popular imagination, this idea of foreclosing the mortgage has a lot of traction. And people still talk about banks foreclosing a mortgage. The reality is today that, yes, that is still an option, even in respect to Torrens title land. It's preserved within the legislative framework, but it is not the option that is most typically utilised. the option that is utilised, which doesn't sound as exotic, I suppose, but it is the reality, and that is the mortgagee is exercising its statutory power of sale under legislation, the LTA. We'll also see, though, that it's not just the Land Title Act that's relevant in this context, but we'll see, so we've got some key terms there as we've been talking about, but the Property Law Act, Part 7, is also relevant. We'll just have a look at that in a moment. The Land Title Act, as I've been saying, Part 6 is the relevant area for mortgages, referred to the National Consumer Credit Protection legislation, which is Commonwealth legislation. The legislation that introduced some changes in relation to mortgages prior to 2010, and then the National Credit Code, which governs specified mortgages, mostly those transactions entered into by individuals for residential purchases after 2010. So there's layers of protection. So just before we get to the idea of what is a mortgage, we'll just stop screen sharing that. I just want to show you the legislation. So firstly, as I mentioned, we've got the Property Law Act, and we've got Part 7 of the PLA, and you can see there just under Part 7, a range of matters being dealt with, obligations in the mortgages, variation, inspection, production of instruments, application for possession by a mortgagor, for example, tacking and further advances. We'll get to that shortly. Powers incident to the estate or interest of the mortgagee, so dealing with both the mortgagor and the mortgagee. Regulation of the power of sale. So there are provisions here dealing with that. And there's also, you can see there, for example, in sub 4, a cross-reference to the Land Title Act, and that's also important. There's also duties on the mortgagee in regard to sale under the PLA, and various other matters that are dealt with there. I just might just move across, just stop screen sharing that. I just want to refer to the screen share. So this is the 2018 PLA review report, which we've been referring to various topics in the unit. Part 7, and now I'm not going to go through all of this. You can have a look at it if you'd like to, and as you already know, this topic isn't examinable in the final exam, but it's an important topic for you to get your heads around and to understand the fundamentals of and the essential concepts. But just interesting to note in the 2018 review that it refers, yes, it's the case that, as we've seen, provisions within the PLA dealing with this area. And notice that in that second paragraph, the authors say in Victoria, it has been noted that much of the law of mortgages is outside of the property legislation. This is equally true in Queensland. This means that a full review of all the laws relating to mortgages is outside the scope of this review. Yes, that's true. So it's just an reference to the National Credit Code in relation to the debt that's entered into under the credit contract. And just, the point here is that the authors are highlighting that the law governing mortgages is not just found in one place. And yes, there are these many provisions within the PLA, and we as lawyers, property lawyers, we need to be mindful of those. But we also need to be critically mindful of the provisions of the Land Title Act, because we're primarily, almost entirely, looking at situation of Torrens title mortgages. Just when we come to the concept, the idea of mortgage shortly, we'll just reiterate what that means. So I'll just stop screen sharing that. And I just want to show you provisions in the Land Title Act. Okay. So you can see that the mortgages is dealt with in the LTA under Part 6, Dealings Directly Affecting Lots, Division 3, Mortgages. We just go into that. You'll see that it deals with the registration of mortgages. We've already seen that earlier in the course in the unit in terms of that you can register, and then that a mortgage can also get into feasibility by registration, the effect of registration, and various other matters. Section 78, powers of mortgagee, very important, and the other provisions dealing with the Torrens nature of that, Torrens nature of the, the Torrens requirements of a Torrens mortgage. Notice section 78, sub 1, a registered mortgage of a lot has the powers and liabilities of a mortgagee under the PLA Part 7. So there's a cross-referencing there between the PLA Part 7 and Part 6, Division 3 of the LTA, particularly with regard to powers of the mortgagee, and this also involves their capacity to enter into a sale transaction where there's been default by the mortgagor, which is the landowner, or the registered proprietor, okay, or the person that's borrowed the finance to support the transaction and to acquire the property. So just need to be aware of that. Okay, so I'll just stop screen sharing that for a moment and come back to the slides. So we've got that, a framework of primarily state-based legislation in Queensland, but we need to also understand the national credit laws that come from the Commonwealth and providing enhanced protections for borrowers, individual borrowers in domestic and residential purchases. So what, the idea of a mortgage does have, such an impact in the popular imagination, and it is really, the way that it's referred to and discussed often suggests it has almost a life of its own. People might say or refer to, do you have a mortgage? The mortgage is a dominant, sort of thread of conversation with regard to property ownership and with regard to that other important relationship that's happening very often, and particularly in the context of residential property acquisitions of land, but acquisitions of commercial property, industrial property, agricultural property. These also can be subject to mortgage, of course, because of the sums of money that are involved and the need for finance. The mortgage is actually, it's a very ancient idea, and it really arose out of, at a very early time where there was a need, of course, to fund acquisitions of land. And what occurred is, over time there was intervention, there was recognition of the relationship by common law, and then there was also an intervention by equity to essentially protect the position of the mortgagor, because historically, under the general law, when someone took out a mortgage over general law land, which is in England, for example, historically, a tiny area, a tiny percentage of land is still possible in some jurisdictions in Australia for there to be general law mortgages. But the idea was that when you took out this mortgage, there was actually a conveyance of the title in the property to the person that was loaning you the money, to the mortgagee. And on the understanding that when you paid out the debt, there would be a reconveyance of the property, of the land, back to the borrower who originally had the legal title in the property. Over time, there were situations where mortgagees, despite a debt being paid out, wouldn't actually reconvey the land. So this required equities intervention, which led to the recognition of what was ultimately referred to as an equity of redemption, which basically meant that by paying out the loan, there was an obligation to reconvey and to get the interest in the land back. Now, that was the situation under general law, and equity evolved some principles and ideas in relation to that as it went along to further protect the position of the mortgagor and also to some degree regulate how things were done by the mortgagee. In a Torrens title mortgage, which is what we have today in the modern period and in Queensland, the situation is different. So that someone acquires land under the Torrens system and they become the registered proprietor. And as we've seen, they get indefeasibility of title. If at the same time they need finance to assist in the purchase, the lender will require a mortgage over the property. But under the Torrens Act, what occurs is they get a security interest in the land. They do not have the title in the land conveyed to them. So the borrower, who is the registered proprietor, remains the registered proprietor with indefeasible title and the legal owner of the land under the Act. The mortgagee has a secured interest, and that can be registered on title and become an encumbrance on title. And if you search the registered mortgage will be revealed. And then within the mortgage itself, there are covenants and provisions that specify the relationship between the parties. And most typically, one of those is that despite the fact that the mortgagor continues to have legal title, there will be a covenant within the mortgage to say that they can't do things in regard to the land unless they seek the approval of the mortgagee. So that will be a further burdening of what they can do and restriction, if you like, but it's down to the covenants that are confined within the mortgage instrument. It's not in any way defeating their registered proprietorship or the fact that they continue to be the owner of the land, notwithstanding the existence of a Torrens mortgage. Now, we also need to understand, as we've been mentioning, that there's two transactions or two relationships, a better way to put it, on foot. So we have a loan contract and we have a mortgage. Loan contracts are signed and completed, and the Consumer Credit Code becomes very, very important in this context, but it also applies to mortgages over land and how this works through the way it's defined. And it sort of works in terms of, looking at the link between the loan contract and the mortgage, but it essentially is focusing on the loan contract and how that is undertaken and the nature of the terms and conditions in that. And they need to be reasonable and they need to be fair and not overly burdensome in regard to the borrower, and the statutory scheme provides an array of protections and options in terms of that particular contract. And then there are also, as pointed out there, implications in terms of consumer protection provisions through the application of this framework. What we're mostly concerned with in our discussions here, though, is how property law is governing this relationship. And further, our focus is on the Torrens mortgage. So we've seen that relevant provisions in the Land Title Act So I'll just show you that again. So you can see there, section 74, the effect of registration of a mortgage. A registered mortgage of a lot or an interest in a lot operates only as a charge on the land or interest for the debt or liability secured by the mortgage. Okay, so this term becomes relevant in terms of linking the debt that is secured. And back in the earlier assessment, you were having fun games with the relationship between the loan contract and the mortgage and the debt being secured, and was that reflected in the mortgage? So this provision has a relevance in that context. And the critical point here is that it's the nature of the interest that's acquired by the mortgagee under the Torrens Act. It's a security interest. They don't get title in the property. Okay, so I'll just go back to the slides. And we can see there that you can have a look at the Forest Trust decision, 1953 Victorian decision, in relation to that. And you can see that discussed in your casebook at 11.23 capital C, starting at page 1076, just as an example of explaining the nature of a Torrens system mortgage. We now also need to appreciate, as you looked at and worked with earlier in the unit, in relation to verification of identity matters, sections 11 capital A and 11 capital B of the Land Title Act in Queensland, but not in every jurisdiction, but also in other jurisdictions, putting extra requirements upon the mortgagee to identify the identity of the mortgagor that they're entering into a transaction with. This was to overcome, really sloppy banking practices, mortgages being given without really full investigation of those that were signing and executing documents. As the earlier assessment also helped you to appreciate, under the arrangements we have today, we have electronic documents, and we now have the national mortgage form, of course, as we've seen, in which you've experienced. If a transaction, even a standalone mortgage, let alone as part of a purchase, but even as a standalone mortgage, if it's undertaken as an electronic electronic conveyancing system through PEXA, then we have a situation where the solicitors then, as subscribers, are completing documents and executing documents on behalf of clients. So we then have other issues arising in terms of the relationship between what the lawyers are doing, and in this case, for what the bank's doing, or the mortgagee is doing, in fulfilling the statutory obligations with regard to proof of mortgagee mortgagor identity. Now, a further issue in this dimension at the minute is there's a requirement, as many of you identified at the moment, in this aspect to have face-to-face meetings, to just, so that's a required element in terms of this VOI, right? But going forward, one can say, well, look, surely with the further evolution of technology, we can't be limited to face-to-face meetings. It'll become to a degree impractical. We then have to ask, well, how can potentially, for example, video conferencing or screencasting or whatever play a role? But that then takes us to another challenge in the electronic conveyancing environment, where we've found that fraudulent behaviour starts to creep in, as it does very typically. And we've now got this manifestation of what's referred to as deep faking. Some of you discussed that then, or I brought it to your attention earlier in the unit. So a number of challenges here around this. So the point I'm making is that that's now embedded in the legislation, and it is a requirement, and it requires mortgagees to exercise appropriate due process. And if they don't, it can actually lead to the mortgage being unenforceable, as you explored and discussed in that earlier assessment. But the evolution of technology is making the application of this, even in the modern period now, since these provisions were incorporated, increasingly under challenge in terms of operational viability. So we just need to always be mindful of the constant evolution, both in terms of the law on the one hand, but also in terms of how things are actually happening out there in the world. And sometimes the law has to play catch up, but you then also need to see how the law can work to accommodate these changes, because obviously we are working within whatever legal requirement and legal framework exists at the time. Just on this point about priorities and tacking, I don't want to sort of labour the idea of priorities. We've really looked at that earlier in the unit. And it's the idea of this tacking is tacking further advances onto a mortgage. That also takes us back to something that we looked at earlier in the unit, and that is the all monies mortgage. And that was something that was tossed up in the earlier assessment as well. That is the idea that, that this mortgage is not just about one sum, but it's actually a mortgage that allows further amounts, or it has a flexibility about it. And the covenants of the mortgage need to reflect that to ensure that the security secures the full extent of what is being advanced under the contract. Here we find again this correlation between the terms of the contract and what the mortgage reflects. Because again, when we think back to the earlier discussions around indefeasibility, the loan contract and its terms, of course, are not registered under the torrent system. What's registered is the mortgage and the terms of the mortgage. And when you do a title search, all you see is the registered number of the mortgage, and then you can go and follow that up and you can look at what's in the mortgage. But further to that, common practice today, a lot of mortgagees and banks and financiers is they will have a standard set of terms or covenants or provisions in a standard registered document. Then they'll make reference to that in the particular mortgage that is being entered into with a client on a particular occasion. So there's a number of steps to follow in terms of seeing the whole picture, in terms of the terms and the covenants between the parties. And yet we saw back in the early part of our thinking around torrent system, that this is a public register, and what you see by examining the public register is what should reveal everything that touches the title. Do you need to go behind the register? This idea of the curtain principle. And so this is sort of, to some degree, being a bit challenged by current practice. And so just have an awareness of that, and also the ideas that are informing that. In terms of priorities between Torrens system mortgages, again, we saw the mercantile credits case previously and how that was relevant and the degree of protection that was provided in terms of the registered mortgage. We've also seen earlier an assessment on this question in dealing with unregistered interests, and very typically those, again, the types of unregistered interests that crop up are mortgages. Yes, again, it's quite a common theme that's flowing through the unit insofar as a category of interest that is relevant and important in various ways, because it is very much a part of the transactions in regard to acquiring interests or disposing of interests in land. Okay, and we see there that we've got provisions within both the LTA and the PLA on this. And I don't need to show you that, but it's again, the idea here is around the priority in terms of registration. Registered instruments have priority according to when each of them was lodged, not according to when each of them was executed. Okay, so not when the mortgage was completed, but when it was lodged for registration. That's what will give priority in terms of registered mortgages. But as you've seen, the situation is different if we're dealing with unregistered interests and competition around that in regard to Torrens land. And we also see, as we said before, that the Property Law Act is relevant here. And we see that Section 82 and 84.3 is relevant. 82 deals with the taking of further advances, and that goes back to the nature of the mortgage and whether it's an all monies mortgage or a different, facility mortgage or whatever. And 84 is important here because it's about regulating the exercise of the power of sale. And so in terms of the way in which that's to take place, that provision is also important for you to appreciate. Now, the next area, which is important, is for us to think about the covenants in mortgages. These are the terms and conditions that are found within the mortgage that is essentially between the parties, determining the rights and obligations, responsibilities between the two parties to the mortgage instrument, the mortgage transaction. And you'll see these discussed in your casebook, pages 1090 to 1091. Just be aware again that we've got provisions within the PLA that are dealing with these. And the terms, the covenants don't change whether we're talking about a general law or a Torrens mortgage, and they deal with matters like the amount of the loan, the rate of the interest, when is the loan to be repaid, and also provide a framework for the fact that the mortgagee's security doesn't get interfered with. And then there's also issues about when the mortgagee is in possession of the land and what requirements are there and obligations arise. So you can have a look at those provisions and those sections from the PLA in terms of the usual sort of covenants that you expect to see. In your casebook, for example, the discussion with regard to Queensland is over on page 1091. So, for example, the authors say, in Queensland, a covenant to pay principal and interest is also implied. The expression that the mortgagor conveys as beneficial owner implies certain covenants for title in the general law mortgage. The legislation also implies certain powers in the mortgagee, and the mortgage is made, or is made by deeder in Queensland by an instrument. So the terminology is not exactly the same across the jurisdictions. We're focusing on the situation in Queensland, and also just note, for example, the last sentence there in your casebook, certain covenants are implied in Torrens system mortgages, and then there's a reference to section 167 of the Queensland legislation. So you can just have a look at that as well. Now we need to consider the remedies of the parties where there's a default under the mortgage. So most typically, mortgagor is in default in repayment of the amount specified in the mortgage and when they're to fall due and so forth. Now, and this is dealt with in your casebook starting on page 1091, and we deal first with the remedies of the mortgagor, who is the under the Torrens system as the land title holder. And then we look at the remedies of the mortgagee. Okay. So we start with by considering the fact that there's been an important role for equity in this situation, and again, the development and the involvement of equity harks back to the general law mortgage that evolved over time and the role that equity took in that situation. That's had continuing influence, and of course you can have mortgages not just in relation to land, but you can have them in relation to intangible property, shares, for example, acquisition of shares, for instance. And some of the cases in your casebook on this section is really about that, but the principles apply across to Torrens mortgages. And one of the reasons for that is because of an equitable idea that essentially a mortgage is a mortgage. Okay, and there's, for example, in the Queensland, which I referred to in the slides there, the Queensland decision of Sun Development and Dale, which is a 2014 decision of the Queensland Supreme Court. There's a quote there taken from the earlier English decision of Samuel. You can see there on page 1104. And the quote is, I'll just read this to you because it's helpful. The doctrine, once a mortgage, always a mortgage, means that no contract between a mortgagor and a mortgagee made at the time of the mortgage and as part of the mortgage transaction, or in other words, as one of the terms of the loan, can be valid if it prevents the mortgagor from getting back his property or paying off what is due on his security. Any bargain which has that effect is invalid and is inconsistent with the transaction being a mortgage. So what the court is saying there, drawing on that earlier decision, which evolved out of the general law of mortgages, not Torrens title type mortgages, is saying, well, look, a mortgage is a mortgage, that's it. And over time, what's evolved is these equitable protections that are part of the mortgage transaction. And one of these protections is referred to as the equity of redemption. I mentioned that just at the outset of the lecture. This equity of redemption means that the mortgagor can get the interest in the land back on full repayment of the outstanding debt. Now, we've already said that there isn't a conveyance and a reconveyance of land in the Torrens system. However, because of these ideas that a mortgage is a mortgage and the frameworks have generic application, this idea of attempts to prohibit or to inhibit this equity of redemption are not acceptable. That's the bottom line. And that's what we refer to as clogs on the equity of redemption. This idea of trying to prevent the mortgagor from getting access to their full entitlement. Now, in terms of the implications of that for the torrent system, that essentially means that that there can't be limitations on, once the debt has been paid off, that there will not be a right to have the mortgage discharged. And the application can be made in a document, instrument lodged to discharge the mortgage. And even if you can go back and have a look at the PEXA materials under electronic conveyancing, you'll see there is a process there for discharge of mortgage. So if the debt has been fully repaid, it's not acceptable for the mortgagee to continue to insist upon the mortgage being on foot. There will be a right to have that mortgage discharged. Whether the mortgagor decides to keep the mortgage on foot for other practical reasons is a different issue, and sometimes that is the case, because if they want to potentially in the future refinance to do further things with regard to the property, rather than going through all the processes of having to approve a mortgage again, they may seek to have that mortgage facility remain in place even though there's no outstanding debt. So that's the reason why these ideas that are drawn out of history and the evolution of the general law mortgage have relevance in the context of Torrens title. What's interesting in this discussion around clogs on the equity of redemption is that you had, there's a couple of cases there, and I've referred to the Sun Development. Before that, there's the Westfield Holdings, an Australian Capital Television case, which is a decision of the Equity Division of the Supreme Court of New South Wales in 1992, the judgment of Justice Young. Why is that case there? Well, again, both this and indeed the Sun North case are in relation to transactions involving shares, not involving land. So why there? Well, this idea of the discussion around the equity of redemption won't appear in those terms with regard to Torrens because of the different way it's operating. But as I've just mentioned, how it actually manifests is through this right of being able to discharge the mortgage. So the discussion of this in the modern period is actually in a different context, but the idea still has relevance. Why are we looking at this 1992 New South Wales decision and in this later Queensland decision? The reason is because Peter Young, Justice of the Supreme Court in New South Wales, basically is looking at the situation of the way that this notion of the clogs on the equity of redemption works in a commercial environment. And if the commercial parties have put terms into their transaction which actually facilitates this in a way that, for example, allows the mortgagee to exercise an option to purchase the property at hand, if shares, it could be shares, for example. Young is actually coming to the conclusion that, well, that's actually acceptable and we need to understand that in the modern period. So a strict adherence to this idea that there cannot be any clogs on the equity of redemption, well, we need to accommodate that within modern understanding of commercial practice. So he says, for example, at the end of his judgment there on page 1102 in your casebook, in my view, in 1992, the rule only applies where the mortgagee obtains a collateral advantage, which in all the circumstances is either unfair or unconscionable. So there's the idea of unconscionability, which is a bit of a lightning rod in equity, of course, in the modern period. It might be that the court presumes that the mere fact of a collateral advantage, presumes from the mere fact of a collateral advantage that the transaction is unconscionable unless there is evidence to the contrary. But the principle does not extend to invalidate automatically cases in which the mortgagee has obtained the right to purchase the whole or part of the mortgage property in certain circumstances, or has obtained a collateral advantage where the circumstances show that there has been no unfairness or unconscionable conduct. Coming across to Sun North, there was a different view. And so the judgment which you have there of Henry in the Queensland Supreme Court, again involving a transaction involving shares, there's discussion around this whole idea of the clog on the equity of redemption in that context. And the judgment of Henry is that, well, we have in fact two separate transactions where we're looking at an option to purchase and we've got a loan agreement. So he says, for example, on 1104, paragraph just before the subheading, should the Westfield approach be followed? The option and the loan agreement and the other documents were part and parcel of what was in substance one transaction. The option formed part of and was in substance security for a mortgage transaction and was an impermissible fetter on the plaintiff's equity of redemption. It was void from the outset. In considering whether he is bound by or should follow the Westfield approach, which was articulated by Justice Young, he doesn't believe that he should follow Young's reasoning. And if you look over on page 1105 under the heading, the Westfield approach involves a departure from established law, the failure of the Westfield approach to give determinative weight to the inherently unconscientious nature of the transaction as an automatic foundation for intervention involves a departure from established law. And over on 1106 of your casebook, he refuses to follow it. So there's a stricter view here about the role of equity in terms of preserving this equity of redemption, even in a commercial situation, even in a transaction involving shares, not land. And there's an idea of the relevance of unconscionability in terms of equity's involvement there, which is important to appreciate. And then we just need to see, well, that has an impact back on how we understand things in the Torrens situation. We also need to be mindful of potential penal provisions in mortgages which will be invalid. Okay, so you can have a look at that, and that's discussed on page 1107 at paragraph 11.58. Okay, and there's also implications of the National Credit Code with regard to penal provisions. In terms of the remedies of the mortgagee, now these are probably arguably under a Torrens mortgage, the matters that get more careful attention, because it's typically the case that it's the mortgagee that's doing something when the mortgagor has defaulted on the loan or on the obligations specified in the mortgage with regard to repayment of the sums when and as they fall due. It's important to understand that what the mortgagee can do in that situation is, in regard to Torrens mortgages, is regulated by legislation. And it's here that we refer to the provisions of the Land Title Act. We've seen reference to section 77, 83, 84. And the points that come out of this is that what we need to establish is that this exercise of this sale by the mortgagee, there needs to be certain things as preconditions, if you like, before that step can be taken, because it's a pretty drastic step with its impact upon the landholder, the mortgagor. Okay, that's the reason and the rationale for these layers of protection and stipulation of process. So to start with, we need default in payment of principal or interest or other money secured by the mortgage for a particular period. We need breach of some other covenant in the mortgage, and we need failure to remedy the breach for a specified period after notice has been given. So you can see there's a number of requirements there before the sale trigger can even be activated. Right? So that's important to appreciate. And then what we have is really an understanding of how the statutory power is being able to be exercised and what are the stipulations there. You'll see, for example, in your casebook that the various features of this look at, for example, there's a statutory duty, first of all, to give notice to the mortgagor, and then there's an equitable duty in terms of how the sale is being conducted. Particular concerns arise where mortgagee sales are being facilitated towards associated companies. We saw that in the J&H Just case, and also we saw it in the Terrigal decision earlier, where that's effectively what was taking place. Of course, you know, you can have private sales, private treaty, sale by private treaty, or you can have auction sales, and very typically mortgagee sales occur in that way. And the stipulations around what is required in terms of that, and what are the obligations of the mortgagee in that regard. So have a look at those features in terms of the exercise of the power of sale, and what, for example, the notice requires and how that's to be brought to the attention of the mortgagor and so on. In terms of the conduct of sale, as I was just referring to, this is an equitable duty, and once the notice period has expired, then the mortgagee has an equitable duty to ensure the sale is conducted fairly, balancing the interests of both mortgagor and mortgagee. Now you can see here that this type of a sale is rather different to a standard sale transaction. So that standard sale transaction, the seller is looking for their best interest and their best outcome. They're not so concerned about, you know, looking towards the interest of potential purchasers. They're trying to get the best deal they can out of selling their property. And it's up to the purchasers to do various things and to make various inquiries. Certain matters have to be revealed in the sale process, yes, but it's very much each party looking out for themselves in a sense. In this transaction, that's not the case. We have a requirement from equity that the mortgagee must be balancing their interests with the interests of the mortgagor, who are the title owner, okay? Because of the severe impact this is going to have of basically taking title away from the mortgagor. Okay, so there are various aspects there in terms of that balancing process with regard to dealing with the sale, with regard to dealing with the debt, with regard to how the sale takes place, how it's advertised, and what price is obtained at the end. As I mentioned before, this idea of sale to a related party, and you can have a look at the those discussion of the decision in Bagadilli, which is referred to there in relation to that. The other features in this process basically involve, does the equitable duty amount to a negligence test? That is, has the mortgagee been negligent in how it's conducted the sale? Is that what is required? The issue around the timing of the sale, how does that make a difference? You know, if it's a quick sale, you ask questions about, you know, has due process been followed, balancing, you know, the balancing factors in terms of particularly the mortgagor's interests, and note the statutory duties in the exercise of the power of sale under section 85(1) and 1A, and we might just have a look at those. So I'll just screen share that with you. So we can see there that 85.1, right, it is the duty of a mortgagee, including as attorney for the mortgagor, or a receiver acting under a power delegated to the receiver by a mortgagee, in the exercise of the power of sale conferred by the instrument mortgage, to take reasonable care to ensure that the property is sold at market value. 1A, 1 capital A. Also, if the mortgage is prescribed mortgage, the duty imposed by sub 1 includes that the mortgage or receiver must, unless the mortgagee or receiver has reasonable cause. And then there, you can see that there are a range of matters specified. Now, the point to be noted here is that these statutory requirements in Queensland are not uniform across jurisdictions. So, for example, you can see discussion in your casebook at the bottom of page 1129. Queensland has introduced duties on mortgagees exercising the power of sale. These duties involve a more stringent test that is closer to common law negligence type duty than the equitable good faith duty. So in Queensland, what we've had is a more stringent test being put into place. You can see there through an amendment 1 capital A in section 85 of the LTA. And that's not the same stringency of requirements reflected in all jurisdictions. So just need to be aware of that. Let's come back to the slides again. And we can have a court-ordered sale under section 99 of the PLA, so just be mindful of that. The court can get involved in certain circumstances in relation to the sale process. In terms of the sale transaction itself, of course, when a sale occurs, we've now got 3 parties, essentially, or 3 entities that are involved in this situation. If there are issues being raised about the sale, the mortgagee sale. So we've got the mortgagee who's selling the property under power of sale. We've got the mortgagor to whom obligations are owed in that type of a transaction as the existing landholder or registered proprietor. We've then got the incoming purchaser under the mortgagee sale. And if, for example, the transaction and the transfer has been registered under a mortgagee sale, the torrent system would suggest that that purchaser requires indefeasible title. Well, how does this work in this situation where there are allegations of impropriety or statutory non-compliance by the mortgagee in effecting a mortgagee sale? So in this context, we have reference to the classic decision, which is always referred to, of Forsyth and Blundell, which is a 1973 High Court decision. And we had a situation there, it was a commercial situation, involving a petrol station, and more than one mortgage. And the issues arose as to whether or not the requirements had been met for due process being followed by the mortgagee in the sale transaction. And so you just need to have a look, if you have an interest, at the Forsyth and Blundell case, which provides further clarification around the nature of that protection of the purchaser in that situation of a mortgagee sale. And you can see also that there's more recent Queensland decision of Tenderis and Ogle in 2004. We now just touch upon I might just, before we go to before that, I'll just go back to Forsyth and Bundle for a moment. I just want to point out that on page 1145 of your casebook, just point out the comment there made in regard to the Forsyth case. So as Forsyth and Blundell demonstrates, the court will set aside an improper sale, notwithstanding that the purchaser entered into the contract without notice of the improper exercise of the power. In the absence of statutory protection, the position of the purchaser who does not have notice of the impropriety until after completion of the sale is not improved. So that's interesting. Okay. And then a bit further down, Queensland's purchaser protection provision, section 87, was applied in the Tendris case. So if we just have a look at section 87, I'll just show you section 87. And you can see there that that's provision dealing with the protection of purchasers in mortgagee sales. And you can have a look at that and its impact. And as pointed out there, that 2004 Supreme Court decision in Queensland discusses the application of section 87. So just come back. To the slides, and so we're now moving on and considering the idea of foreclosure, and this is dealt with under section 99 of the Property Law Act. You can have a look at that. Foreclosure is essentially the right of the mortgagee in the event of default in the payment of principal interest to vest ownership of the beneficial title in themselves in full discharge of the loan agreement. So this is this idea of foreclosure. It basically means that where this occurs, the mortgagor's equity of redemption is discharged and the mortgagee becomes the absolute unencumbered owner of the land. So you can see effectively that's the outcome of foreclosure, and you can hopefully appreciate why it's not really the remedy that the most mortgagees in terms of financial organisations are interested in today. They're not really wanting to become the owner of the land. What they want is to satisfy the unpaid debt, and they're going to do that by selling the property, most typically, to meet that unpaid financial obligation from the defaulting mortgagor. But it is important just to be mindful and to recognise that foreclosure continues to exist, and it is still part of the framework of the law that governs mortgages, and despite its significance within the popular debate, as I said earlier in the lecture, it's not irrelevant, it's still there, but a less of a practical remedy for most mortgagees in the modern period. And in terms of the relevance under the Torrens system, we see that Section 78 of the Land Title Act is relevant because it essentially retains that remedy of foreclosure, but there's qualifications in Queensland, and the orders there can be made by the registrar, as we see. And there's also the mortgagee can sue on personal covenants, and just be mindful of that dimension of the mortgagee's entitlements. We also see that there's, again, as I said, this right to sue on personal covenants. There's power to appoint a receiver in different situations. And then we also need to appreciate the nature of equitable mortgages, where we've seen this earlier in the unit, where in fact the mortgage hasn't been registered, and how we deal with that and what mortgagees can do in situations in that regard. We also have these ideas that there is under the general relation of obligations between the parties, the mortgagor and mortgagee, that that there's certain rights that are specified in the framework in regard to the opportunity, the right to redeem, which is governed by provisions in the PLA and also by the National Credit Code. The right to possession, and that's dealt with under the Land Title Act. What is the power of a mortgagee to lease? Again, dealt with under the Land Title Act, Section 66. And then lastly, the rights of a mortgagor and a mortgagee against third parties. And that, again, is dealt with under the specified legislation, PLA and LTO. So, folks, that brings us to the end of topic 10 on mortgages. And what we've been looking at is the nature of a mortgage, specifically in the Queensland context, the Torrens title mortgage. We've been concerned to have an awareness of the national credit legislation and the National Credit Code. Importantly, in terms of the law of mortgages governed by property law, to understand the rights and obligations of the parties to the mortgage, that is the mortgagor and the mortgagee, and the nature of the remedies that both mortgagor and mortgagee can have. In particular, when we're thinking about the mortgagee's remedies, we're focusing on the power of sale under the legislation. Yes, they do have a right of foreclosure, and that has been preserved, but the primary entitlement is one of a sale, but there are a number of steps they must follow. There are a number of conditions that must be met before they can trigger that sale. And then when they conduct the sale, there are a number of responsibilities and obligations that they need to fulfill in relation to that, not just in terms of fulfilling their statutory duties, but in specifically balancing the interests of mortgagee and mortgagor. So it's a different type of transaction, and it's a different process to a standard sale transaction. And then we've seen also that they have a right of foreclosure. And there are other sort of dimensions of their rights and entitlements as well. So, folks, the mortgage is a critical interest in property, because it is basically about the security interest in property. It is the security interest that is had in land that is what enables the financial facilitation of transactions in land, acquisitions, purchases, and the law governing that property law relationship between mortgagor and mortgagee is very important. But as we've seen throughout the unit, the mortgage, the instrument of mortgage resonates in various ways in land law, and has a significance because it is a very significant relationship in land transactions. So, folks, there we are. That's the end of topic 10, and that's the conclusion of land law. So, until you next get excited about wanting to further your studies in property and land law, that's all. Bye for now.